Yeah, 2009 was, in my mind, a great deal of continuation of the patterns and trends that we've seen in 2007 and 2008. There have been a large number of individual prosecutions, a large number of corporate cases. They've spanned across industries and also delved deeply into specific industries, and we're now hearing that the pharmaceutical industry may be the target industry for 2010. And so for me, I think the trends that we saw in 2009 are the trends that we saw in 2008, and they're going to be the trends that we'll see in 2010 as well. The most likely civil cases that are follow-on or parallel to the government cases, the enforcement actions, be they SEC or Department of Justice, will come from shareholders. You'll see derivative actions, you'll see straight shareholder suits. Those tend to be the most common, but I think the point to note here, and that's really not a surprise when you look at plaintiffs' lawyers and the plaintiffs' bar in corporate cases. But the part that I think is surprising is the number of non-shareholder, non-derivative actions. Cases by competitors, cases by agents, cases by joint venturers, cases that come up from individual employees that are pointing out bribery-related issues or relying on bribery-related issues in advancing their claims. So the shareholder suits aren't a surprise, but the scope of the number of actions and the directions from which they're coming is a little bit of a surprise. Well, I think you have a plaintiff's bar that is continually trolling for new potential causes of action, and so I think a large portion of it is dependent on the plaintiff's bar bringing cases under new theories. But I think the growing prominence and mainstreaming of the FCPA into everyday law has influenced the types of civil cases that are brought. I think the mainstreaming and the plaintiff's bar are probably the two reasons that we are seeing this big uptick in cases. The outcome of a criminal case has dramatic impact on a civil matter. Certainly there can be collateral estoppel related issues if there are admissions in settlements, things along those lines. So I think a resolution of a criminal case in which liability is conceded will have dramatic effects and be greatly assistive to plaintiffs. But what we're seeing more and more of is people bringing lawsuits in the midst of an investigation, before an investigation is complete, and sometimes before an investigation has even been initiated by the U.S. government. And so the timing is moving up and up and up for these collateral civil cases. They're not waiting for the government to conclude its investigation, but they're bringing them earlier and earlier in the process. I think that in the past, certainly you saw dramatic stock drops as a result of the announcement of an investigation, and that has certainly led companies to think about how it is they're going to go about and broadcast that they are under investigation. Certainly, being charged and having bribery allegations put against you is tremendously harmful from a reputational standpoint. But the fact that we are seeing more and more of these cases and the FCPA is becoming such a common tool of enforcement, it may not have the same kinds of dramatic effects going forward as it has had in the past.